Ladies and gentlemen, it's our great pleasure to have such prominent panelists here. Before I introduce them formally, please take a note. The view expressed here by the panelists in the session are their personal views only and should not be attributed to their organization. The information provided should not be relied upon for business purpose or taking into consideration legal advice. The gentleman next to me is another superstar. He has many celebrity clients. And it's Mr. Stephen Anderson. He is, of course, experts for many, many years. He's also the district attorney, I think he's a deputy state attorney, and been on trial for many cases. He has served clients like Luminar Pictures, FIFA, wow, FIFA, the football eagles, and the Avengers program, and TC, the Hard Rock Cafe, Licensing Corporation, Kingfisher, Syndicate, 20th Century Fox Pictures, and many, many celebrity and many prestigious companies. He supervised and called the local counsel in the international Buddha litigation in different countries. Stephen has been a guest lecturer for Ortiz Institution of Art and Design for Orange County Bar Association and a featured speaker for National Business Institution and the European University Institution in Florence, Italy, and Brussels, and Bond IP days in Munich, Germany.
Say you change your name, or I'm not doing it anymore. Ferrari said we don't use the Testarossa anymore. They took it away. So again, how to prove, what to prove. Again, I suggest you can take a look at these slides for the details. I'm trying to move through quick. But if you go out and say, I've abandoned it because you haven't showed it for 10 years, again, you've won. You've got the other guy done. And I mentioned the Kitty Clover case where he said, I don't want to use those potato chips. We're not going to sell Kitty Clover anymore. We're going to a new name. And that statement is sufficient to show that guy doesn't even want to use it. He's not using it. He said in the press. So again, INTA has offered some methods of proving how to do non-use in the U.S. perspective. Look, I can't sell alcohol without a license from the government. I can't be a lawyer without a license to practice law. You don't have a license, you can't do the job. If I prove that you don't have a license, you're going to have a heck of a time to show you somehow are selling without government approval. Also, the distributors, again, you can check in with their colleagues in the industry and find out what's really happening and use that as evidence. Anyway, again, these have been a little bit shifted, but I really hope you'll take a look at those for the specifics. But again, we're just trying to get through what is it and why. One court has said that, hey, if I use the mark abroad, let's say I'm the most famous mark, Desigual, in Portugal, that doesn't constitute use in the United States, so they still need to demonstrate that the Desigual Portuguese goods are being sold and distributed in the United States. It could be the famous mark in the world, but I'm Disney. And they say, I don't care if you're not using it in the United States, you don't get to keep your edge. So this is the case that Michael touched on, Armbruchter Stagecoach. It came out about 2 years ago. In this case, the owner of the registration had been making fancy limousines for hearses and funerals for many, many, many years. It was a very famous brand. But alas, over time, I guess people didn't want to buy a lot of fancy Cadillacs.
Professor Anderson would like to talk about abandonment in the USA, please.
Thank you. I'm actually pleasantly surprised that all my colleagues covered so much of the preliminary material that we're able to jump right into the meat of my discussion, which is basically what is abandonment based on non-use, and how do we challenge and address those very issues. It seems to be resonating through each of my co-panelists' discussion, and I'm pleased to see that. This is not the first time I've presented on this subject. However, I'm very pleased to say that rather than rehashing old law, there was recently, just this month, actually a month ago this week, on October 1st, a new decision, precedential decision by the Trademark Trial and Appeal Board on this very issue. So not only do I get to bring you up to the very latest in the law, but as you will see, this involves some of the most interesting geopolitical issues of our time that have never been addressed before. And with that, I'll get going. Use it or lose it. Abandonment in the United States. As our colleagues indicated, if you are not demonstrating use of a mark, whether at the various stages or even during litigation, you can lose that mark either by the TTAB cancellation or even in litigation. Judges have the authority to strike your mark for various reasons, including fraud and non-use, if it's presented by a defendant as a defense to an infringement action. So obviously, the question is, when do I need to show use in commerce? Well, generally it's about 3 times in the life cycle of a short application and or registration. We all know that before any mark in the United States will be registered to anyone, you must demonstrate either a bona fide intent to use and or actual use. So in order to get a mark registered, there's of course the one exception for Madrid and foreign marks that come in, which are able to get registered defensively the first time. But if you want to renew that mark, you've got to show use now after between 5 and 6 years, and then again at each 10 years thereafter. So even though you may have been able to get that mark registered in the United States, to keep it, you've got to demonstrate that use and provide those specimens. So that's what makes those other issues so important, because not only are you going to have to do it at certain points in the life cycle, but if you get involved in an opposition or cancellation action, if you get involved in litigation in court, the defendant may raise, I want to see that use because he's abandoned. So what is abandonment and non-use, and how do we determine that? We've talked about that. Again, use in commerce, intent to use, 44. What are those things? Again, I will make these slides available so you have the actual data rather than simply repeat that. Again, when does it require to show use? As I mentioned, either for US-based applications or intent to use before registration. And again, at the end of the 5th year, before the 6th year, and every 10 years thereafter. So we've gone over that. Now, what is use in commerce? I think Michael did that quite well, and Brent touched on it a bit. But again, when we're talking about goods, things, tangible items, I want to see it on those goods. I want to see it on their containers. I want to see it on displays. But most importantly, I want to see that those goods have been sold in the U.S. You can provide me a photograph of a product here in Taiwan, but that doesn't prove it's in use in the United States, so that becomes an issue, how to demonstrate use in U.S. commerce. Oftentimes, as Tommy indicated, we can show a clip from Amazon. Hey, look, they're selling my product on Amazon, and here's today's date. Clearly, I can buy it to be delivered in the United States. That constitutes use of goods. For services, that's a little trickier, because let's say I'm doing an outsource service such as telephone bank, but as long as it's been provided for and through United States commerce, that is adequate for service. But how do I demonstrate that? Every website in the world might show service, but how do I know it's being used in the United States? So anyway, these are the kinds of issues that we're going to be going over with respect to services to show that they're rendered in commerce. And the fun thing about that is it means U.S. commerce, not just commerce generally. So it can be tricky, and it can be something that'll trip you up at that time when you need to show those specimens. Moving on. Where do I think? Well, I think it's this one here. No?
It's
Oh, yeah.
it's there's a, I think it's not we have to it's the
After when?
Okay.
it's
All right. So again,
okay.
There you go.
thank you. We did that. Abandonment. Now, what is abandonment? Abandonment is failure to use a mark, of course, but the question for how long and on what basis. Many of my friends from India understand the case of World War I. There are some exceptions to non-use that are permissible, but those may not meet the statutory requirements showing use at various times. But we can say if someone has not used the mark for 3 years, they got a presumption against abandonment. Now the defendants in the driver's seat show, now you've got to show use. Otherwise, up till that 3 years, it's the defendant's position to show he's not using it. And while Brett talked about the Couture case, think about that. Disney's got to prove that somebody else isn't using it. So that can be very difficult because they have greater, that is, the opponent has greater information about how they use it. So it's oftentimes based on allegations followed up by discovery, and typically those cases get settled before they get to the courts. But when they do, abandonment is required to be strictly proven. In other words, if I can't prove you're not using it, then you are. But if I can prove you haven't used it for 3 years, then it's presumed that you are abandoned, and it shifts back to the plaintiff or the owner to show use. So it's kind of interesting. What is abandonment? This is an interesting case. Richard Brevard v. Linville. It's an older case. But how do you prove the other guy isn't using it? That case was quite interesting. The guy was selling potato chips, and he made an announcement saying, well, we don't like that trademark anymore. We're going to switch. Recently, just this week, the Ford company said, we're no longer going to make the Flex vehicle. To me, that's a discussion that they have abandoned that mark, or at least certainly have an intention not to reuse that mark and therefore make it vulnerable. So when you go out and you say that to the world, hey, I don't care, I'm not going to use it anymore, well, it goes back to the plaintiff, because you said so, and I can show that as evidence that you didn't use it, or you don't even intend to use it. So now the plaintiff has to come forward with that evidence. So it's an interesting ping-pong game to see who has to prove and what burden of proof to show those specimens in non-use. Generally, though, anyone trying to prove that the other guy has abandoned has that burden of proof. That's both in the federal courts and in the TTAB. Therefore, you at least have to come forward with some kind of evidence of abandonment. You can't just blindly say, as Brett suggested, well, I'll say you didn't have a bona fide intent to use it, hope comes out in the wash. You better prove it, or you're just not going to make your elements. Now, self-serving and conclusory statements don't do. Websites don't do. So you've got to show that packaging. You've got to show that commerce. Sometimes you might even have to show an invoice. While the invoices themselves are not specimens of use, certainly if I can show that I sold 100 widgets last month, I can demonstrate widgets are on sale. They were delivered to a buyer in the United States. Interesting thing about change of the form of the mark. Let's say we've altered our mark over the years. It was a design mark with a flower, but now we decided to make it a little cooler. That can constitute abandonment. You've got to use the registered mark, not some variation. So again, I said, if you